Hello, everybody. Thank you very much for joining us today. I'm Annabelle Mace, partner and head of the business immigration team, and I'm joined by May Chung, who is a director in our team. We're delighted that you can join us for this webinar. Just a few housekeeping points before we start. So during the presentation, all participants will be in listen-only mode, but if you experience any technical difficulties, you can send a message via the Q&A panel asking for assistance. Just select host and press send, and that will be picked up by our IT team. As a reminder, this session is being recorded and we will be sending a copy of the slides and a recording after the event. As we go through the session, please do feel free to ask any questions in the Q&A panel on the lower right hand side of the screen. We've also set aside some time for Q&A at the end, so please do feel free to ask as many questions as you like. You can type your questions into the text field, select the drop down as all panelists and press send, and we will try and answer all of these questions as we go through the session. And if we can't do them during the session, we'll try and pick them up when we send out our mailing afterwards. So to kick off, I've started with this quote here, which was in the explanatory memorandum to the statement of changes that was published last Thursday. So it reflects what was announced in December. The government's aim is for businesses to invest in the resident workforce rather than over relying on migration. So arguably that's a very sensible aim, not to be overly reliant on migration, if indeed that is currently the case. But the changes that we're going to talk about today that are being introduced are really quite dramatic, and some have described them as the biggest shake-up since the new points-based system was introduced in December 2020. And we don't yet know what the unintended consequences of those changes will be, whether the government's goals will be achieved. We'll just have to see. What we're going to try and do today is summarise and clarify the 300 odd plus pages that were published last Thursday, so that you don't have to wade through them yourselves. And we'll try and draw out what we see as the key issues, the immediate actions, and some of the longer term implications. I've mentioned about asking questions in the Q&A, but actually it doesn't have to be questions. If you've got general observations you would like to share or concerns, then please do feel free, and we'll sort of bring those in as part of the discussion as we're going through. So what are we going to cover today? Just very quickly in summary, obviously talking about changes to the skilled worker rules, the salary increase in the thresholds, some all-important transitional arrangements which lots of clients have been asking about since the announcement was first made in December, what the immigration salary list is, changes to the subcodes, a couple of case studies. We'll talk about some of the other changes from the 4th of April, and as I said, trying to pull out from all of this what you really need to be thinking about and how to plan going forward. So I'm going to ask May to launch in straight away with the salary increases now. Over to you, May.
Thank you. So the first and probably most important change that we're expecting from the 4th of April is the increase of salary. The general position for skilled worker visa is that the salary threshold has gone up. So it's gone up from 26,200 to 38,700 per annum, which is a big jump. But in reality, there's probably the actual salary is going to be higher than that. And the reason for that is because the minimum going rate is also jumping from the 25th percentile to the 50th percentile from the 4th of April. Okay, so the minimum salary threshold is what everyone has to pay anyway. If you want to sponsor someone under the skilled worker visa, you need to make sure the salary threshold is met initially, unless there is another discount or they're under transitional. The going rate varies depending on the role you want to sponsor. So there is a list of different jobs on the government website with different salary rates, and then we need to match the job to the relevant subcode, and then from that we can determine what the minimum salary rate is. So what do we mean when we talk about it's gone from 25th percentile to 50th percentile? So the salary currently that we've got on the going rate is not based on the average salary paid in the UK. So it's more the 25th percentile of the median salary based on the Office of National Statistics, ONS data. Going forward, the salary will be based on 50th percentile of those rates, very, very much closer to the average salary they think it is being paid in the UK. But that's probably not taking into account the regional salaries, which will be lower than what's paid in London. So just to give you an idea, for example, a business development manager role at the moment is the minimum going rate at the moment is 35,100 under the 25th percentile. Going forward, under the new rules, under the 50th percentile from 4th of April, the same job, you need to pay £52,500 in order to sponsor for that position. So that's a £17,000 jump in salary. Luckily, there are some transitional arrangements in place, and those are for anyone who's got a visa under the rules in place by 3rd of April this year. If they've got that skilled worker visa already, then the salary threshold will be at 29,000 per annum, slightly increased from 26,200, but not too much. But the going rate, more importantly, will still be at 25th percentile, albeit it'll increase slightly over the years, just to make sure it's going up on an annual basis. I mean, we did notice this year, the salary, the slight increase that they mentioned is not quite as slight as it is. So going back to the example on the BD manager, the new rate based on the 25th percentile going from the 4th of April will be 39,100, which is more than 10% increase from the current rate. The next slide, please. So moving on to the new entrant salary. So the new entrant is a lower salary rate that can be paid to those who are just graduating or just finished the degree in the UK or younger and haven't got as much experience, so below 26 years old, switching from graduate visas, switching from student visas in the UK, and they haven't got as much work experience. So the government, what they've done is that they've allowed them to work, to be sponsored in their skilled worker visa based on a lower salary initially. And then they'll have to be, the salary will need to be increased when they extend their stay later on. So there is a maximum period that individuals can be based on the new entrant salary, and that's 4 years for most individuals, unless they've already spent some time under the graduate visa, which gets deducted from the 4 years. So luckily, this new entrant rate is still there, but the actual salary threshold has gone up. So the threshold is currently £20,960,000, but then going up, it's going forward, it's going to be 30,960, which you can see there's a £10,000 increase. So it might not benefit all sponsors wishing to employ graduates who, if they can't afford the higher salary threshold going forward. Next slide, please. So the health and educational roles haven't changed. They're the only categories that the government has said they're not going to increase the salary threshold for. So that's good. I mean, the minimum salary threshold has gone up to 23,200, but it's minimum. And the rate, it's still going to be the national pay scale rates. So because there is the change itself is very minor, there's no transitional arrangement for this category. Okay. So moving on to the shortage occupation list. So the shortage occupation list, for those who don't know, is currently the list of occupations that are deemed in shortage in the UK. And there is a 20% discount to the salary on the going rate for those sponsoring under these roles. What the government have decided to do is to scrap the shortage occupation list, replace it with something called the immigration salary list. Okay, but the immigration salary list will not have the 20% salary discount. Okay, but it does have a lower salary threshold of 30,960 compared to the 38,700 we talked about for the general threshold. But then, because the minimum threshold itself is 30,960, which is quite high, and there isn't a 20% salary discount, the higher salary of the minimum salary rate is usually going to be higher than that, because it's going to be more based on the 50th percentile salary. So just to clarify, the salary going forward for those on the immigration salary list is going to be either £30,960 or the going rate based on the 50th percentile, which is usually higher. And because the salary rate is usually higher and there's not going to be much benefits for those roles that are currently on the list, which have a higher salary than the 30,960, Migration Advisory Committee decided to recommend the government to remove most of the roles from this list. And it's now left with just 23 occupations. And you can see from this slide what are left. And you can see that the list is very limited. And the only reason why these roles are still on the immigration salary list is because their going rate is below 30,960. So they could benefit from the lower salary threshold. The IT roles, engineering roles are all gone. So similarly with the other slides, just to look at the salary threshold going forward, and there's the summaries on the table. So you can see the current rate, you can see the new rates, and also there is a transitional rate for those who were on the shortage occupation list, for roles that were on the shortage occupation list and not on the immigration salary list. So what happens is that the transitional arrangement is a lower salary threshold, and the 20% discount will still apply based on 25th percentile salary rate. But this transitional arrangement only applies to those who have a visa under a shortage occupation role at the moment and is extending their visa to work for the same sponsor for the same role. So if they're changing sponsors post 4th of April, then the transitional arrangement would not apply, but they'll still benefit from the general transitional arrangement, which is the 29,000 threshold and the minimum and the 25th percentile without the discount. Okay. And on that note, I will pass you back to Annabelle to talk about the other changes.
Thank you, May. So the other sort of key change, just to bring to your attention quickly, is that the Home Office, actually on the recommendation of the MAC, have decided to update the kind of role coding system that the Home Office uses for sponsorship, which is it's a long overdue change, but the system is currently used. We use it when going forward with a visa application, because what it does is it states, it sort of lists out particular roles or categories of role, and each role or category has a particular code, and that code specifies the minimum going rate salary. So what's happening going forward is that they've updated the system, which needs to be done, but the net effect is that lots of occupational codes have now been renumbered, which is going to cause quite a lot of confusion. And then sponsors will need to be careful that they've chosen the correct code, particularly when they're extending the visa of someone that is already sponsored. And I've given a couple of examples here of where the actual numbering is going to change. Sponsors need to be quite careful about this, because if you use an incorrect code when sponsoring somebody, the salary threshold that you then end up with may be higher or lower than what actually needs to be paid, and that could lead to an application being refused at the application stage, even if the Home Office don't pick up on that at the application stage. If the application was approved, but actually you were sponsoring someone or allowing somebody to work under an incorrect code, that is a breach of their conditions of their permission. The Home Office could view that as illegal working, and so that could have quite serious compliance implications, both in terms of your sponsorship duties and the general point about preventing illegal working. The change in coding system also means that actually some of the roles that qualify for sponsorship under the current SOC 2010 system are no longer included in SOC 2020, so they simply won't qualify for sponsorship. And then in addition, surprisingly, what we found is that there are some roles in the SOC 2020 coding system that didn't exist under the 2010 system, which means some roles which we didn't think would, which don't currently qualify for sponsorship, will qualify for sponsorship going forward. So all pretty confusing. It doesn't really help sponsors when they're going through that process of trying to choose the right code and the right salary. And then more generally, I suppose that the overall point is just to make that, given the increase in salaries across the board, it may just be that some of the roles that you've been accustomed to sponsoring can no longer be sponsored because that minimum threshold exceeds what the market salary for that role actually is, regardless of what the ONS put forward as their median data salary. And that's as May said, that's particularly for businesses that are outside London and in the regions, I think will struggle with these salary increases. What I've just done here is include an extract from the table in the statement of changes. So this is just for one role, but what it does is show you, so this is kind of demonstrating the new salary, the codes going forward and the salaries. And it kind of gives you an idea of the different salary options depending on whether someone is new to skilled worker, whether they have a PhD in a STEM subject, whether they're on the immigration salary list, if they're a new entrant. So all of these factors create a different salary requirement. Table 1 is those sort of categories that I've mentioned. Table 2, lower down the screen, are the kind of the options, the salary options that you would use in the event that somebody is in a health and care visa or under a transitional arrangement. So it kind of just gives you this general idea of how much more complex this is going to be going forward. Overall, you don't need to worry about this too much because it's just really to illustrate that whereas now you could pretty much say off the top of your head, oh, that role is a particular code and yes, they'll qualify for sponsorship. Going forward, it's much more the case that you wouldn't be able to, be confident that someone will qualify for sponsorship unless you looked at this table, because there are so many different permutations. And you can see here in the bottom left-hand corner, as an IT project manager was previously sponsored under code 2134 under the SOC 2010 system. And going forward, that number is now changed to 2131, just to confuse everybody. So I think that's probably enough technical detail for now. We're going to try and bring some of this to life with a couple of case studies. So in our first case study, we have a business called Marketing Moguls. They employ Jenny as an advertising account manager with a graduate visa, which expires in September 2024. So Jenny's not currently sponsored. Doesn't have a salary restriction or minimum threshold, but because her graduate visa will not be extendable, she can't apply for another graduate visa in September 2024. Marketing Moguls will have to consider whether or not they're going to sponsor her at some point. So the question is, do they try, and this is probably the number one question we have been looking into for clients since the announcements were made in December. The question is, do they try and sponsor her before the 4th of April under the current rules, before the salary threshold goes up, or can they wait, sort of try and maximise her time on the graduate visa and wait to sponsor her closer to her visa expiry in September 24, but that will obviously be after the rules have changed on April the 4th. And what we also need to consider at the same time is if they do go on to sponsor her, whether they do that now before the rules change or after the 4th of April, would there be a further salary increase at the end of that 2-year visa, so at some point in 2026? So May, what do you think about this particular situation?
Yeah, this is the number one common question we're getting at the moment. The answer actually depends on what the salary Jenny is going to be paid. So if Jenny's salary is already going to be very high and above the going rate under the new rules, say, so the new rules, you can see in the slide, the going rate is going to be 40,000. Say the salary is already 45,000 or much higher, then we don't really need to worry about applying for a visa now, because she can actually just wait and, you know, utilize her graduate visa until September and switch closer to time. Of course, there might be other incentives for her to switch earlier, because, you know, it'll start the 5 years clock to get indefinitely to remain. And for companies, you know, you can retain her on your license because you're sponsoring her. But in terms of rules, that doesn't matter in terms of salary. But if the salary that Jenny is going to be paid is lower than the requirement under the new threshold, then you need to look into it. Okay, and this is because if Jenny is able to switch her visa before the rule change on the 4th of April, then she does benefit from the transitional arrangements going forward that we were talking about earlier. So this minimum salary threshold right now is already much lower for the new entrant and for the going rate. She switches over, and then on extension, say she had to rely on the new entrant rate, 22,050, and then she had to extend the visa in 2 years' time based on the higher rate, experienced worker rate. Then the experienced worker rate that would apply would be the one under the transitional arrangement for those already holding a visa under the skilled worker visa. So that is lower, that is 32,600. So the company needs to consider if that is something that they could pay as well in 2 years' time. Whereas if she doesn't apply right now, she might qualify to apply under the new entrant rate based on the £30,960 or initially. But then after 2 years, when she is extending a visa, will her salary be able to extend to 40,000 or more or higher based on the going rate at that time? So things that the company needs to consider is what the salary they're going to be paying now, what the salary is expected as well, and probably wise, if you can, to switch earlier to the skilled worker visa so she can be covered by transitional.
Thank you. Next question.
Next question is about shortage occupation list. And for this question, we have fast forward ourselves to 3 weeks' time. So this is after 4th of April. The rules have now changed, and we have a software company, Software for You, have come over to ask about this candidate, Marco. And he is currently employed by another business as an IT business analyst under the SOC code 2135, which we know is under the current the shortage occupation list before the rules changed. And then the salary Software for You wants to offer Marco is £31,000, which is in line with the salaries paid to other business analysts for the business, and in line with the general salary threshold and going rate for the rules in place before 4th of April. But would Marco qualify under the transitional arrangement based on this 31,000 salary if he's sponsored under the same role, given that he's already had a visa? What do you think, Annabelle?
Well, so he would, Marco would qualify for some sort of transitional arrangement, but not the sort of the whole benefit. So he really, because he is changing sponsor, albeit he's in the same role, because he's changing sponsor, he won't be able to rely on the 20% discount that applied to the salary threshold when he was on the shortage occupation list. So there is a risk, well, for this new employer sort of seeking to make this offer to him, they would have to pay him at least 39,000 or offer him at least 39,300 rather than the 31,000 that they're used to paying, and which is currently a line for sponsored workers in that role, and those sponsored workers that they already have could continue with that salary, so that, you know, there's no immediate need to increase their salaries. But if they wanted to offer Marco a role, they would be in this difficult position of needing to offer a higher salary because he doesn't get the full benefit of the transitional arrangement. If he stays put and he doesn't change role, then his current employer wouldn't need to increase his salary, or would need to increase marginally to 31,440 at the point of extension. So it's just having that general awareness of when you're going through the hiring process of sponsored employees, there may also be a hike in salary, even if they're partially covered by the transitional arrangement. This then also raises a broader issue of what Software for You will need to do if they really do want to sponsor Marco. So if they say, okay, we really need him, so we are going to, increase that salary to 39,300. If they want to sponsor him, even if that's above the market rate. But then that, you've got to then think about does that mean raising the salaries of their other IT business analyst roles? And if they don't do that, if they don't bring those other IT analyst roles in line with Marco's new salary, you're going to have sort of ER issues, potential discrimination or equal pay claims. So there are going to be longer term implications, and I'm not sure if the Home Office has necessarily thought through what the impact will be of increasing salaries in this way. If they do increase the other IT analyst roles to be in line with Marco, does that then have a knock-on effect in other IT type roles within the organisation or within the salary structure within the organisation generally? So lots really to kind of think about just on the basis of these salary increases. So hopefully those case studies have given you a bit of an idea of the types of issue to be looking at, particularly in relation to the salary increases for skilled workers. Just quickly on some of the other changes that we anticipate, which will come into force on the 4th of April. So very quickly, some of you may use what we call the global GBM route, the global business mobility route, previously known as the intra-company transfer. So interestingly, the general salary threshold for that role, for that route, is going up by about £3,000, but the ONS data is not being updated, so the going rates for those roles are remaining at the 25th percentile. We're not sure quite why the Home Office has decided not to increase the going rate threshold to the 50th percentile in line with the increase for the skilled worker visas, but it's perhaps because they see this route as a temporary route, so it doesn't really have a significant effect on net migration. And similarly, a small increase for graduate trainees under the GBM route. Slightly different topic. There's something called, there's a provision called supplementary work, which is being expanded. So skilled workers are currently able to undertake limited supplementary employment, by which we mean work for another sponsor, who is another organisation who is not their sponsor, providing they remain working for their original sponsor in their sponsored role. And that supplementary employment has to be outside their contracted working hours and for no more than 20 hours a week. And currently that employment must be in the same occupation, the same professional level as a sponsored role, or in an occupation on the shortage occupation list. For whatever reason, the Home Office have decided to expand that sort of allowance, and it now means that that a skilled worker could undertake any supplementary work, providing it's within it would be for a role which otherwise qualifies for sponsorship. So slight kind of surprise in why they've extended that category, but it might be helpful for some employers. So to reflect now on what those immediate action points are, and I think some of these are things that you would have been looking at already since the announcements came out in December 2023. So, and this is what we've sort of been generally saying in our blog posts and articles on the topic. So be looking at your current workforce to see if any of them need to be switched into the skilled worker route, for example, because they're on graduate visas or student visas, or any visa for that matter that's not a skilled worker visa, looking to see who you need to switch over before the 4th of April, and sort of putting that in process as quickly as possible, because we're obviously getting much closer to that date. You may also be looking at your current sponsored employees who are coming up for a visa extension in the next 3 months. Not necessarily because they would be covered by the transitional arrangements. You wouldn't get that massive hike from the 25th percentile to the 50th percentile, but you would get some, on extension, you may get some moderate salary increase in line with the ONS 2023 updated pay data. So it may, if you're concerned, if that seemingly moderate increase is going to be difficult for you for that particular role, then you should consider sponsoring that or extending that person's visa before the 4th of April. If you do need to sponsor individuals who are already working for you in the UK, or they're already resident in the UK, so you'll be going to be doing an in-country application, an in-country switch, then you will need something called an undefined cause to be able, certificate of sponsorship, to be able to do that. Those are the certificates that sit kind of waiting to be used on your sponsor license. Those are notoriously difficult to come by. The Home Office can take 18 weeks or more to issue those once you've made a request. There is a priority service that you can use to request those certificates to be allocated more quickly, but those are issued on a first come first served basis, and so it can be very difficult to get hold of. You will need a cause allocation if you want to do a new visa application in country before the rules take place on change on the 4th of April. And then lastly, just think in terms of immediate action points, just think about what that material kind of salary increases is going to be if you're sponsoring new hires under the skilled worker route for the first time, i.e. they're not going to be covered by transitional arrangements. So just look ahead in terms of, these are the roles that we need to recruit for. In the meantime, we had allocated, we had expected to be paying them this particular salary, but now we realise, because of the increase in the going rate to the 50th percentile, that actually those salaries are going to have to be much higher if we're going to sponsor them at all. And it may be in some cases that you simply are unable to sponsor them because the required salary is way above your market rate. And then on top of that, so we talked about the immediate issues to be considered. We really need, we're talking to clients about what are the longer term implications. We're really not sure yet. We've got an idea of what the intended and unintended consequences of these changes will be, but time will tell how this pans out in practice. We now, obviously from listening to us, you'll have gathered that eligibility for sponsorship is just going to be more complicated, costly and time consuming. It's all manageable. It's something that, that you will be able to get through, but it's a lot to contend with, on top of other pressures on businesses to hire the best and the best workers for their vacancies. It is going to require you to look quite carefully at your recruitment strategies. So as I said before, it might be that there are certain roles which you are used to sponsoring and you simply can't do that going forward because the salary requirements are too high, unless a transitional arrangement applies. If you can't fill those roles with sponsored employees, you need to be thinking about what you will do to fill those roles. Will you be forced actually to raise salaries, which has the implications I was talking about earlier, the knock-on effect for other employees, or will those roles simply go unfilled? And so what interim and longer term steps do you need to put in place to account for the fact that you've got unfilled vacancies? The changes may also have an impact on your existing sponsored employees. If they stay with you, their salaries don't need to increase just because of these changes on the 4th of April, at least until they're due for extension, when there might be a moderate salary increase. But if other sponsors are struggling to fill certain roles with sponsored employees and they start to increase salaries as a result of the April the 4th changes, there may then be a greater incentive for your sponsored employees to start looking elsewhere. So you're going to, on top of the challenges, the recruitment challenges, the skills shortages that you're currently facing, you may see further movement of sponsored employees to other employers. And in a broader sense, if you're hiring for a particular role, and one of the candidates requires sponsorship, but the salary you are able to pay, so your standard salary for that role, falls below the sponsorship rates, we're often asked the question, well, can you simply choose not to sponsor that role? And the answer to that would be yes. You know, in that situation, your justification for not sponsoring would be, objectively, this role with the salary we would typically pay just doesn't qualify for sponsorship. So you would be able to say, we can't, you know, this is not a role we're able to sponsor, it doesn't qualify for sponsorship. That's a slightly different argument to where a role and the salary does qualify for sponsorship. It meets the salary thresholds that are coming into place on the 4th of April. But where there is a tendency, understandably, within some organisations not to want to sponsor a particular role because the sponsor doesn't want to incur the cost of sponsorship, i.e. the Home Office application fees. So that's a different type of justification, and a refusal in that situation could lead to indirect discrimination claims, because it's difficult to rely on cost alone as an objective justification in that scenario, particularly for an organisation of any particular size. So there is some justification, there is some potentially helpful case law that relates to using cost as an objective justification, but that case law relates to indirect age discrimination. So we couldn't guarantee that a tribunal would apply the same principles to an immigration scenario. So generally speaking, I'd be cautious about the reasons you use for refusing to sponsor a candidate or an existing employee. If it's objectively that this role and the salary we generally pay will not qualify for sponsorship, fine. If it's about the costs that the business might incur, for example, the application fees and so on, then that's much more difficult to use as an objective justification against a discrimination claim, particularly because quite a few of the costs can be passed on to the employee. So that's a whole, I appreciate that's a whole other topic, but something that's worth raising in this context of salary increases. And then very quickly, just to mention that the graduate visa route is also being reviewed by the Migration Advisory Committee. So that falls outside the 4th of April changes, but I'm mentioning it now because there's a possibility that that route could be withdrawn at quite short notice in the government's attempt to try and sort of reduce net migration. And if that happens, the business's sort of general pool of international graduates, which you've relied on as an alternative to sponsorship, that could largely disappear overnight. So I'm afraid that's sort of an increased pressure on you in terms of recruitment and skill shortages. So changing tack again, and these are, we're going to talk about a few changes which aren't really related to the 4th of April changes. These are things which are sort of in the pipeline throughout the rest of 2024.
Yeah, and actually this is some positive news, despite what we've been talking about on this webinar already. So this is good news in terms of the sponsor license renewals. Earlier this year, we saw on the sponsor license on the SMS account that the Home Office made a note saying they will automatically extend licenses that expire after 6th of April 2024. And looking at the license summary, we can see that they did actually extend a lot of the licenses to 2034, 2036, much in the future. But the license that do expire before 6th of April, you do need to still apply for an extension yourselves. So there is that good news there. Although we do think that the reason the Home Office has done this is because they want to free up some more time so that they can actually deal with compliance issues. And so far, we've already seen there's been an increase in terms of cancellation notices. So when an individual leaves a sponsor, you report to end the sponsorship. And recently, we've seen that the curtailment letters are coming back much quicker than they used to curtail the visa to 60 days. So there is that. And then the enforcement team also on the the Prevention of Illegal Working Front have been increasingly sending more requests to the to different employers to request for information on right to work checks. So there might be a lot more discussions between the Home Office and the HMRC on the illegal working front as well, to see if there's more civil penalties that can be issued. So what we suggest employers to do is that do make sure you do self-audit your files, self-audit in terms of compliance in terms of the sponsored workers records, as well as right to work checks records. Make sure you are also auditing to make sure you are ready for a potential Home Office visit, which can be announced or unannounced. And that moves us on to the civil penalty increases, which happened on the 13th of February 2024 this year. So the fine increased from £20,000 per person to £60,000 per person for any breaches that occurred after 13th of February 2024. I mean, if there was breaches before this date, the old fines of £20,000 per person will still apply. The new statutory code of practice was published to see, to provide more information on how the fine is calculated and how you can mitigate those fines. For example, if an employer reported the breach to the Home Office directly, or if you've done some of the right to work checks, but before they started work, but it wasn't quite in line with the requirements, or if you've fully cooperated with the enforcement team when they came to visit you, then you could apply for a reduction of the fine. But then there will still be a fine in place, and that could still cause a reputational damage. So our obviously advice is that employers should make sure you still conduct the right to work checks fully before the employee starts work with you, to make sure that you can defend the fine. You have the statutory excuse to defend the fine if needed, and that will avoid, any reputational damage, any problems with the sponsor license if you have a sponsor license, and in terms of just the admin and cost for that.
Thank you, May. So a few more changes just to mention before we then move on to the Q&A. You'll have noticed that a lot of employees where you've had sight of, got copies of their BRPs, that many of them will expire on the 31st, have an expiry date of the 31st of December 2024, even if actually their permission kind of continues beyond that. And that's because the actual BRP itself is expiring, not their permission. And what is happening is that as part of the Home Office's drive to digitalise all sort of visa statuses and applications, with effect from the 31st of December, employees will no longer, if they're, for example, travelling in and out of the UK or applying for a new role, will no longer be able to, they will no longer need a BRP, because everybody will be moved across to digital status. There is no action that employers need to take apart from making sure that they've done correct online right to work checks for anyone with a BRP. But in due course, employees with BRPs will be contacted by the Home Office to ask them to register and apply for online digital status, so that they can. That's how they will confirm their status going forward. And in future, all visa applications on the whole, we expect to the applicants to be issued with e-visas, so online digital status, rather than a physical BRP. And as we know, for some time now, since the 6th of April 2022, even if an employee presents with a BRP, you still are required to do an online digital right to work check. You can't rely on taking a copy of the BRP as proof of the right to work. So we anticipate some glitches with this transition across from BRPs, physical BRPs, to purely online digital status. Because just from experience of what's happened to date with some people who do already have e-visas, sometimes there are technical glitches, which means they can't generate a share code to prove their right to work. Sometimes people have issues on entering the UK, and it may well be that even if we're moving across to a kind of digital process where people apply for visas entirely online without having to attend an appointment centre, actually in some cases they will still, you know, have to go to an appointment centre to have their visa application processed. So you know, we'll just have to see how it pans out. I'm sure there will be challenges, because there are currently challenges now, and it is entirely dependent on the sort of the security of the Home Office's IT systems and the resources put into that. And then last but not least, there has been some publicity around ETAs, or electronic travel authorisations, which are gradually being phased in. So for individuals who do not already need a visa for short stays to the UK, over time, before travelling into the UK, they will be required to apply for what we call an ETA. So very similar to an ESTA when you are travelling to the US. At the moment, it only applies to certain nationalities, which you can see there on the screen. It's being phased in over time. There's nothing that you need to do from an employer's perspective. It's just to have that awareness that over time, you know, there will be an extra sort of administrative hurdle for anybody coming to the UK, even as a visitor. But just to bear in mind, an ETA is not the equivalent of permission to work. It's not a visa. It is simply a security issue around getting into the UK. So it doesn't sort of bestow extra additional work rights on anybody that might have an ETA once that's been issued. So just to kind of finish off with some key takeaways from the issues we've been discussing today. As you can see, a significant change, and I'm afraid that there probably will be more. I mean, immigration never stays quiet for very long. We see changes year on year, but particularly in an election year, I think there may be additional changes. And as I mentioned, that the kind of potential withdrawal of the graduate scheme wouldn't surprise me if that came in quite quickly. We know that we can see that navigating these new rules is going to be a challenge for employers. But it is something that we're used to supporting with, and you know, we're always here if people need assistance. It will require more planning ahead relating to sponsorship costs, just in that the general kind of picture of how are you going to sponsor these roles? Can those extra salaries be justified? What is the knock-on effect on other employees? And then on top of that, the Home Office has also asked the Migration Advisory Committee to review stock codes generally. So it may be that there are some roles that qualify for sponsorship in terms of skill level now, but going forward after the MAC review, it's quite possible that further rules will be removed from the list of eligible sponsored roles. And then last but not least, picking up on those slides that May was talking about, particularly in relation to sort of the Home Office having extra resources in relation to sponsor licenses and the increase in civil penalties. We have already seen an increase in compliance actions, both for sponsor duties and prevention of illegal working generally. So it's never been more important to really understand what your sponsor compliance duties are and make sure that you meet those duties. So that brings the sort of our presentation part of the session to an end. We've got quite a few questions.
There's a lot of questions, yeah.
There's a lot of questions. Do you want to sort of pick one, May, and we'll see how many we can get through? We've still got a bit more, 10 minutes before the end of the session, which is great.
Now, first of all, the slides will be shared, everyone who asked. So the slides will be shared and recording will be shared. There's a couple of people who asked questions about the going rates at the moment and where can they be found. So that's already on the gov.uk website under the statement of changes, but that is statement of changes that they propose to put in force from the 4th of April. So there could still be slight changes when the rules actually get announced, but they can be found on the website already.
And as part of these slides, there will be a page with links at the end of the slide deck, and in that we've included a link to the statement of changes. So those the kind of proposed going rates, the new going rates that we're talking about, if you have time to wade through the 300 odd pages of the statement of changes, and I'm warning, the statement of changes is difficult to read, but at the back there are tables that set out what the new going rate salaries are if you would like advance warning. Other than that, other than looking through the statement of changes, I don't think we will probably see them until the 4th of April.
There's a question, Annabelle, on the salary rate on the transitional arrangement, and is there a deadline to apply by? Do you want to take it?
Sorry, I haven't seen that question.
So there's a question about the transitional arrangement.
Okay.
Yeah.
So that will remain in place until 2030. As long as that person is still under the skilled worker route, they will be able to rely on that and for example, given the examples we were talking about earlier, when somebody moves sponsor or role, and so they kind of fall out of the shortage occupation transitional benefit, but generally, yeah, you can remain on those transitional routes for quite some time, providing you're still in the skilled worker under the skilled worker route. I just saw a few questions about the graduate visa. So one of the questions is, if we have employees currently on graduate visas and the government withdraws this, will the employee have until their visa expiry date to remain, please? So so that's a really good question. If the government decides to withdraw the graduate visa route, anybody that was already on the graduate visa route will be okay. It's not like their leave is going to be cancelled or anything like that. They will close the route to new applicants. And so we don't know whether that's definitely going to happen, and if they do decide to withdraw the route, we don't know when they will withdraw it. But it's not unheard of for the Home Office to close a route overnight, which is exactly what happened with the Tier 1 investor route. It was literally closed overnight. So we'll just have to wait and see what happens on that.
There's one question about increasing the salary rate for someone who's been granted a visa recently. Do they need to increase following the transitional rate after the rules have changed? You don't need to increase it straight away. You can increase it on the next extension, next application to the Home Office. So new rates will apply from the 4th of April, but only for applications made after that date.
Just having a scroll through on the other questions. One of the questions is, if we have a few graduates on a post-study work visa, so that's a graduate visa, and their visas will expire towards the end of the year, can we sponsor them in any other way without increasing their salary up to the 39,000? So that kind of neatly ties in with that case study. Maybe this question was asked before we talked about the case study, but that's one of those scenarios where you would be, if you've got someone on graduate visa now and they've still got time to run on that graduate visa, so they've still got the right to work because their visa's not expiring, for example, until 2020 and 24, 25. But you're worried about whether or not you'll be able to meet that salary threshold. The only answer is going to be try and sponsor them under the current lower thresholds before the 4th of April rules kick in. There are very limited other options unless that individual found some other immigration route outside sponsorship. For example, they became a dependent of and got a visa as dependent of a British citizen, or they explored the global talent visa route, but that's for which they don't need a sponsor, but it has a very it's a high threshold in terms of qualifying for that route. So I'm afraid the options are kind of pretty limited unless you can sponsor someone before the 4th of April.
We have another graduate visa under 24, working in IT at the moment. So IT roles have been removed from the immigration salary list. Can we apply for sponsorship for him under the new entrant route? So yes, so the individuals on the graduate visa, so you can apply for the skilled worker visa under the new entrant rate at the moment, but limited to the period, limited to maximum 4 years stay, which is minus the time spent into the graduate visa already. So you can sponsor them, but just watch out for the period you're looking to sponsor them for under the new entrant rate.
And then one of the questions here is, since the final immigration salary list has not been officially released yet, will we be able to sponsor roles based on the old SOC code list? So the immigration, my understanding is, May, correct me if I'm wrong, the new immigration salary list with those limited roles is going to take effect from the 4th of April. So until that date, you can sponsor somebody on the basis of the shortage occupation list at the moment and the salary discounts that you get from that. The MAC has said that the review they have done is an interim review, and therefore there will be, it may be that later in the year they come out with a more detailed list of roles that qualify for this limited salary discount under the new sort of interim immigration salary list. So I guess what I'm trying to say is that what we currently have, and is published in the statement of changes, is an interim salary list. Later in the year, that immigration salary list may change again once the MAC has done a full review.
Yeah, that's correct. And I think even though it's not official, by the 4th of April, the rules will change, and that will be the official salary going forward. So if you're looking to sponsor someone under the immigration salary after the change, you can check the current rate based on the statement of changes, and then going forward, it's going to be likely close to that rate stated on the statement of changes, if you want to plan ahead.
And then someone else has asked here, this is kind of a question really relevant in terms of the timing and the pressure that employers and sponsors are under to get applications in before the 4th of April. So they've asked, what if we are waiting for defined cause and the rules change? Will we need to reapply? So yeah, unfortunately, whether you're waiting to get an undefined or a defined cause, you will need to get that cause allocation through before the 4th of April in order for you to assign that cause before the 4th of April under the current rules. If you can't do that, if you don't get your cause allocation in time until you don't get it until the 4th of April or the 5th of April or later, then you won't be able to sponsor somebody under the rules that are currently in place, and you will be hit by the higher salary threshold, albeit potentially with a transitional arrangement if that applies, unfortunately. So it is a practical issue for a lot of employers about literally trying to get that cause allocation through, whether it's for a defined or an undefined certificate sponsorship. So yeah, that is a really big issue for lots of employers at the moment.
Do we have any more time for another question?
I think we've got one more question. So someone said here, just to clarify, who will the 38,000 wage threshold apply to? So I think that's kind of, it's confusing because from December we've been talking about the increase in the general salary threshold to 38,700. So that's the starting point for all sponsorships, unless a transitional arrangement applies. On top of that, On top of this general salary threshold, you've got these going rates, which are different for each role. And sometimes those going rates are higher than 38,000. And you have to, when you're sponsoring somebody under the new, well, under current rules, when you're sponsoring somebody, you have to pay them the higher of the general threshold. So in this case, 38,000, or the going rate threshold, which might be higher than 38,000 for that particular role. And so it's the rule of thumb is whichever is the higher threshold, the general threshold, or the going rate, you have to pay that higher salary. So when the government first made this announcement in December 2023 about the general salary threshold going up to 38,700, that's correct, but it's not the full picture, because in some cases, depending on the role, the actual salary you need to pay is going to be higher than that general threshold. And I think that's a really tough thing for lots of sponsors at the moment. So I think we've managed to answer almost all of the questions. That just leaves us to say thank you very much for joining us today. We hope you found it helpful. When you're exiting the session, if you could complete the feedback form for us, that would be extremely helpful, including things like different topics you'd like us to cover in the future. Thank you very much and enjoy the rest of your day.
Thank you.